Cpc Foreign Judgement Synopsis. General Foreign Court Definition, Foreign Judgement Definition, Nature and Scope, Object, Illustrations. Jurisdiction of a foreign court, binding nature of foreign judgment principles, foreign judgment when not binding, circumstances, section 13. Foreign judgment not by a competent court, foreign judgment not on merits, foreign judgment against international or Indian law, foreign judgment opposed to natural justice, foreign judgment obtained by fraud, foreign judgment founded on breach of Indian law, presumption as to foreign judgment, section 14. Submission to jurisdiction for a court, foreign court, submission to jurisdiction of foreign court, foreign judgment and res judicata, conclusiveness of foreign judgment, irregularities not affecting foreign judgment, effect of foreign judgment, enforcement of foreign judgment, suit on foreign judgment, execution proceedings, foreign award, execution of foreign judgment. Section 13.14 enact a rule of res judicata in case of foreign judgments. These provisions may embody the principle of private international law that the judgment delivered by a foreign court of competent jurisdiction, private international law. The judgment delivered by a foreign court of competent jurisdiction can be enforced by an Indian court and will operate as res judicata between the parties thereto, except in the cases mentioned in section 13. Foreign court definition. Foreign court is defined as a court situated outside India, not established or continued by the authority of the central government. Foreign judgment definition. Foreign judgment means a judgment of a foreign court. In other words, a foreign judgment means an adjudication by a foreign court upon a matter before it. Thus, judgments delivered by courts in England, France, Germany, USA are foreign judgments. Nature and scope. Section 13 embodies the principle of res judicata in foreign judgments. This provision embodies the principle of private international law that a judgment delivered by a foreign court of competent jurisdiction can be enforced in India. The section is not confined in its application to plaintiffs. A defendant is equally entitled to consult the plaintiff on the basis of a foreign judgment. A defendant is equally entitled to non-suit, not consult, non-suit the plaintiff on the basis of a foreign judgment. Object. The judgment of a foreign court is enforced on the principle that where a court of competent jurisdiction has adjudicated upon a claim, a legal obligation arises to satisfy that claim. The rules of private international law of each state must in the very nature of things differ but by the Committee of Nations. Certain rules are recognized as common to civilized jurisdictions through part of judicial system of each state. These common rules have been adopted to adjudicate upon disputes involving a foreign element and effectuate judgments of foreign courts in certain matters or as a result of international conventions. Such a recognition is accorded not as an act of courtesy but as a consideration of justice, equity and good conscience. An awareness of foreign law in a parallel jurisdiction would be a useful guideline in determining our notions of justice and public policy. We are sovereign within our territory, but it is no derogation of sovereignty to take account of foreign law. As has been rightly observed by a great jurist, we are not so provincial as to say that every solution of a problem is wrong because we deal with it otherwise at home. And we shall not brush aside foreign judicial process unless doing so would violate some fundamental principles of justice, some prevalent conception of good morals, and some deep-rooted tradition of common weal. Illustration. Let us see some illustrations to understand the principle. A sues B in a foreign court. The suit is dismissed. Judgment will operate as a bar to a fresh suit by A against B in India on the same cause of action. A sues B in a foreign court. The suit is decreed. A then sues B on that judgment in India. B will be precluded from putting in issue the matters which directly or substantially in issue before the foreign court and adjudicated upon by that court. A sues B in a foreign court and obtains a decree. He then sues B on that judgment in India. B is not precluded from raising a plea that the judgment of the foreign court is not conclusive and does not operate as res judicata since it was obtained by fraud or it was not given on merits or was contrary to law or was opposed to natural justice, etc. Jurisdiction of a foreign court. It is well settled proposition in private international law that unless a foreign court has jurisdiction in international sense, a judgment delivered by that court would not be recognized or enforced in India. But the jurisdiction which is important in such matters is only the competence of the court, that is, territorial competence over the subject matter and over the defendant. Its competence or jurisdiction in any other sense is not regarded as material by the courts in this country. The material date to decide the jurisdiction of the court is the time when the suit is instituted. Binding nature of the foreign judgment principles. The Code of Civil Procedure provides that a foreign judgment shall be conclusive as to any matter, thereby directly adjudicating upon between the same parties or between parties under whom they or any of them claim litigating under the same title, except where it has not been pronounced by a court of competent jurisdiction, where it has not been given on merits of the case, where it appears on the face of the proceedings to be founded on an incorrect view of international law, or a refusal to recognize the law of India in case in which such law is applicable, where the proceedings in which the judgment was obtained are opposed to natural justice, where it was obtained by fraud, where it sustains a claim founded on a breach of any law in force in India. Foreign judgment, when not binding circumstances, Section 13. Under Section 13 of the Code, a foreign judgment is conclusive and will operate as res judicata between the parties thereto, except in cases mentioned therein. In other words, a foreign judgment is not conclusive as to any matter directly adjudicated upon if one of the conditions specified in clauses A to F of Section 13 is satisfied, and it will then be open to a collateral attack. Lacy rightly states a foreign judgment is conclusive as to any matter thereby adjudicated upon and cannot be impeached for any error, either of fact or of law. In the following 6 cases, a foreign judgment shall not be held conclusive. 1. Foreign judgment not by a competent court, foreign judgment not on merits, foreign judgment against international or Indian law, foreign judgment opposed to natural justice, foreign judgment obtained by fraud, and foreign judgment founded on a breach of Indian law, and foreign judgment not by a competent court. It is a fundamental principle of law that the judgment or order passed by the court which has no jurisdiction is null and void. Thus, the judgment of a foreign court to be conclusive between the parties must be a judgment pronounced by a court of competent jurisdiction. Such judgment must be by a court competent both by the law of the state which has constituted it and in the international sense. It must be directly adjudicated upon matter which is pleaded as res judicata. But what is conclusive is the judgment, that is the final conclusion, and not the reasons for the judgment given by the foreign court. Thus, if A sues B in a foreign court and if the suit is dismissed, decision will operate as a bar to a fresh suit by A in India on the same cause of action. On the other hand, if a decree is passed in favor of A by a foreign court against B and he sues B on a judgment in India, B will be precluded from putting in issue the same matters that were directly and substantially in issue in the suit and adjudicated upon by the foreign court. The leading case in point is the Gurdial Singh versus Raja of Faridkot. In that case, A filed a suit against B in the court of native states of Faridkot, claiming 60,000 alleged to have been misappropriated by B while he was in A's service at Faridkot. B did not appear at the hearing and an ex parte decree was passed against him. B was a native of another native state of Jhind. In 1869, he left Jhind and went to Faridkot to take up service under A, but in 1874, he left A's service and returned to Jhind. The present suit was filed by him in 1879, when he neither resided at Faridkot nor was he domiciled there. On these facts, on general principles of international law, the Faridkot court had no jurisdiction to entertain a suit against B based on a mere personal claim against him. The decree passed by the Faridkot court in these circumstances was an absolute nullity. When A sued B in the court in British India against B on the judgment of Faridkot court, the suit was dismissed on the ground that the Faridkot court had no jurisdiction to entertain the suit. The mere fact that the embezzlement took place at Faridkot was not sufficient to give jurisdiction to the Faridkot court. But if B was residing at Faridkot at the time of the suit, the Faridkot court could have had complete jurisdiction to entertain the suit and pass a decree against him. Similarly, a court has no jurisdiction to pass a decree in respect of immovable property situate in a foreign state. A decree passed by a court in Ceylon against native of India in a suit on a contract who was not residing in Ceylon is a nullity and cannot be enforced by an Indian court. Foreign judgments not on merits. In order to operate as res judicata, a foreign judgment must have been given on merits of the case. A judgment is said to have been given on merits when, after taking evidence, after applying his mind regarding the truth or falsity of the plaintiff's case, the judge decides the case one way or the other. Thus, when the suit is dismissed for default of appearance on the plaintiff or for non-production of documents by the plaintiff, was passed even before the written statement was filed by the defendant, or where the decree was passed in consequence of default of defendant in furnishing security, or after refusing leave to defend. Such judgments are not on merits. However, the mere fact of a decree being ex parte will not necessarily justify a finding that it was not on merits. The real test of deciding whether the judgment was been given on merits or not is to see whether it was merely formally passed as a matter of course or by way of penalty for any conduct of the defendant, or is based upon a consideration of the truth or falsity of the plaintiff's claim, notwithstanding the fact that the evidence was led by him in the absence of the defendant. Foreign judgment against international or Indian law. A judgment based on incorrect view of international law, or a refusal to recognize the law of India where such law is applicable, is not conclusive. But the mistake must be apparent on the face of the proceedings. Thus, whereas in a suit is instituted in England on the basis of a contract made in India, the English court erroneously applied English law. The judgment of the court is covered by this clause, inasmuch as it is a general principle of private international law that rights and liabilities of parties to a contract are governed by the place where the contract is made. Lex loci contractus. When, therefore, a foreign judgment is founded on a jurisdiction or on the ground not recognized by Indian law or international law, it is a judgment which is in defiance of the law. Hence, it is not conclusive of the matters adjudicated therein, and therefore unenforceable in this country. Foreign judgment opposed to natural justice. It is the essence of a judgment of a court, and it must be obtained after due observance of the judicial process. That is, court rendering the judgment must observe the minimum requirements of natural justice. It must be composed of impartial persons, act fairly, without bias, and in good faith. It must give reasonable notice to the parties to the dispute and afford each party adequate opportunity of presenting his case. A judgment which is the result of bias and want of impartiality on the part of a judge will be regarded as a nullity and the trial quorum non judice. Thus, a judgment given without notice of the suit to the defendant or without affording a reasonable opportunity of representing his case is opposed to natural justice. Similarly, a judgment against a party not properly represented in the proceedings or where the judge was biased is contrary to natural justice and therefore does not operate as res judicata. But the expression natural justice in clause D of section 13 relates to irregularities in procedure rather than to the merits of the case. A foreign judgment of a competent court therefore is conclusive even if it proceeds on an erroneous view of the evidence or the law, if the minimum requirement of the judicial process are assured. Thus, the correctness of the judgment in law or in evidence is not predicated as a condition for recognition of its conclusiveness by the municipal court. Thus, a foreign judgment is not open to attack on the ground that the law of domicile has not been properly applied in deciding the validity of adoption, or that the court disagrees with the conclusions of the foreign court. If otherwise, the principles of natural justice have been complied with. Foreign judgment obtained by fraud. It is a well-established principle of private international law that if a foreign judgment is obtained by fraud, it will not operate as res judicata. It has been said that fraud and justice never dwell together. Fraus et jus, non quam cohabitant, and fraud and deceit ought to benefit none. Fraus et dolus, nemini patrocinari debent. Lord Denning observed, no judgment of a court, no order of a minister can be allowed to stand if it has been obtained by fraud. Cheshire rightly states that it is firmly established that a foreign judgment is impeachable for fraud, in the sense that upon proof of fraud, it cannot be enforced by action in England. All judgments, whether pronounced by domestic or foreign courts, are void if obtained by fraud, for fraud vitiates the most solemn proceedings of court of justice. Explaining the nature of fraud, De Grey stated that though a judgment would be res judicata and not impeachable from within, it might be impeachable from without. In other words, though it is not permissible to show that the court was mistaken, it might be shown that it was misled. There is an essential distinction between mistake and trickery. The clear implication of the distinction is that an action to set aside a judgment cannot be brought on the ground it has been decided wrongly, namely that on merits the decision was one which should not have been rendered, but it can be set aside if the court was imposed upon or tricked into giving the judgment. Recently, A.V. Papaya Shastri versus Government of AP, Supreme Court observed fraud may be defined as an act of deliberate deception with the design of securing some unfair or undeserved benefit of taking undue advantage of another. In fraud, one gains at the cost of another. Even most solemn proceedings stand vitiated if they are actuated by fraud. Fraud is thus an extrinsic collateral act which vitiates all judicial acts, whether in rem or in personam. The principle of finality of litigation cannot be stretched to the extent of an absurdity that it can be utilized as an engine of oppression by dishonest and fraudulent litigants. In the leading case of Satya versus Tejasvi, a husband obtained a decree of divorce against his wife from an American court, averring that he was domiciled in America. Observing that the husband was not a bona fide resident or domicile of America, and that he had played fraud on a foreign court, falsely representing to it incorrect jurisdictional fact, Supreme Court held that the decree was without jurisdiction and hence a nullity. Again in Narasimha versus Venkat Lakshmi, a husband obtained a decree of divorce against B, the wife, again from an American court on the ground that he was a resident of America. Then he remarried C. B filed a criminal complaint against A and C for bigamy. A and C filed an application for discharge. Dismissing the application, the Supreme Court held that the decree of dissolution of marriage was without jurisdiction inasmuch as neither the marriage was solemnized nor the parties last resided together in America. It was therefore unenforceable in India. In SP Chengalvarayudu versus Jagannath, Supreme Court stated, it is a settled proposition of law that a judgment or a decree obtained by playing fraud on the court is a nullity and a non-est in the eyes of law. Such a judgment or decree by the first court or by the highest court has to be treated as a nullity by every court, whether superior or inferior. It can be challenged in any court, even in collateral proceedings. In A.V. Papaya Shastri versus Government of AP, after referring to a leading case on the point, the Supreme Court stated, it is the settled proposition of law that a judgment, decree or order obtained by playing fraud on the court, tribunal or authority is a nullity and a non-est in the eye of law. Such a judgment, decree or order by the first court or by the final court has to be treated as a nullity by every court, superior or inferior. It can be challenged in any court at any time in appeal, revision, writ or even collateral proceedings. The fraud may be either fraud on the part of the party invalidating a foreign judgment in whose favor the judgment is given, or fraud on the court pronouncing a judgment. Such fraud, however, should not be merely constructive but must be actually fraud consisting of representations designed or intended to mislead. A mere concealment of fact is not sufficient to avoid a foreign judgment. The High Court of Madras has held merely because the plaintiff obtains a decree upon perjured evidence. It cannot be said that the decree has been obtained by fraud. It is submitted that the view expressed by the High Court of Madras appears to be erroneous in view of the above discussion and does not lay down the correct law. Foreign judgment founded on breach of Indian law. Where a foreign judgment is founded on a breach of any law in force in India, it would not be enforced in India. Rules of private international law cannot be adopted mechanically and blindly. Every case which comes before Indian court must be decided in accordance with Indian law. It is implicit that our foreign law must not offend our public policy. Thus, a foreign judgment for a gaming debt or a claim on which is barred under law of limitation in India is not conclusive. Similarly, a decree for a divorce passed by a foreign court cannot be confirmed by an Indian court if under the Indian law the marriage is indissoluble. It is implicit that the foreign law and foreign judgment would not offend our public policy. Presumption as to foreign judgment, Section 14. Section 14 of the Code declares that the court shall presume upon the production of any document purporting to be a certified copy of a foreign judgment that such a judgment was pronounced by a court of competent jurisdiction unless the contrary appears on record or is proved. However, if for the admissibility of such copy any further condition is required to be fulfilled, it can be admitted in evidence only if that condition is satisfied. Thus, in Narasimha versus Venkat Lakshmi, Supreme Court held that mere production of a photostat copy of a decree of a foreign court is not sufficient. It is required to be certified by a representative of the central government in America. Submission of jurisdiction of foreign court. It is well established that one of the principles on which foreign courts are recognized to internationally competent is voluntary submission of the party to the jurisdiction of such foreign court. The reason behind this principle is that taking a chance of judgment in his favor by submitting to the jurisdiction of the court, it is not open to the party to turn around when the judgment is against him and to contend that the court had no jurisdiction. Submission to jurisdiction of a foreign court may be an express or implied. Whether the defendant has or has not submitted to the jurisdiction of a foreign court is a question of fact which must be decided in the light of the facts and circumstances of each case. Foreign judgment in res judicata. A foreign judgment is conclusive as to any matter adjudicated upon by a competent foreign court. Section 13 of the Code in essence enacts a rule of res judicata in relation to foreign judgments. Hence, if a foreign judgment is delivered by a court having jurisdiction in the matter, it would operate as res judicata. Conclusiveness of a foreign judgment, as stated above, a foreign judgment is conclusive and will operate as res judicata between the parties and privates, though not strangers. It is firmly established that a foreign judgment can be examined from the point of view of competence but not of errors. In considering whether a judgment of a foreign court is conclusive, the courts in India will not require whether conclusions recorded by a foreign court are correct or findings otherwise tenable. In other words, the court will not go into the merits of the original claim, and it shall be conclusive as to any matter thereby directly adjudicated upon between the same parties, subject to exceptions enumerated A to F, section 13. Irregularities not affecting foreign judgment. There is a distinction between want of jurisdiction and irregular exercise of jurisdiction. In the former case, a decree passed by a court is nullity and honest. In the latter case, a decree is merely irregular or wrong, but not without jurisdiction and cannot be ignored. Once a foreign court has jurisdiction in the matter, the decree passed by it cannot be held to be without jurisdiction. In R. Vishwanathan versus Ruknul Mulk, Syed Abdul Shah, judge stated, in considering whether a judgment of a foreign court is conclusive, the court in India will not inquire whether conclusions recorded thereby are supported by the evidence or otherwise correct, because the binding character of the judgment may be displaced only by establishing that the case falls within one or more of the 6 clauses of section 13 and not otherwise. Effect of a foreign judgment. A foreign judgment is conclusive as to any matter adjudicated upon between the parties. Such a judgment is conclusive, binding, and would create res judicata between the same parties or between parties under whom they or any of them claim. Enforcement of a foreign judgment. A foreign judgment which is conclusive under section 13 of the Code can be enforced in India in the following ways: by instituting a suit on such foreign judgment or by instituting execution proceedings on suit on foreign judgment. As a foreign judgment may be enforced by instituting a suit on such foreign judgment. The general principle of law is that any decision by a foreign court, tribunal, or quasi-judicial authority is not enforceable in a country unless such decision is embodied in a decree of a court of that country. In such suit, the court cannot go into the merits of the original claim. It shall be conclusive as to any matter thereby directly adjudicated upon between the same parties. Such a suit must be filed within a period of 3 years from the date of judgment, execution proceedings. A foreign judgment may also be enforced by proceedings in execution in certain specified cases mentioned in section 44A of the Code. The said section provides that where a certified copy of a decree of any of the superior court of any reciprocating territory has been filed in a district court, the decree may be executed in India as if it had been passed by a district court. When a foreign judgment is sought to be executed under section 44A, it will be open to the judgment debtor to take all objections which would have been open to him under section 13 if a suit had been filed on such judgment. The fact that out of 6 exceptions there has been due compliance with some of the conditions and there has been no violation of some of the exceptions is of the no avail. The decree can be executed under section 44A only if all the conditions of 13A to F are satisfied. Foreign award. An award passed by a foreign arbitrator and enforceable in a country where it was made can be enforced in India. The execution of a foreign judgment which is conclusive and does not fall within the mischief of any of the clauses 8F of Section 13 of the Code may be enforced by taking out execution proceedings in India.